Now I think it's working. So thank you very much, Professor James Gordley, for us in our group of research of philosophy of private law. It's a great honor to receive you here to talk with us with this subject that is a great subject that we studied for many years in our group of research. This connection between law and justice, specifically in private law. We have today with us many scholars from our university and other universities in Brazil. The University of São Paulo, University of Minas Gerais, and the Federal University of Rio Grande do Sul too. So we will have a first presentation with 40 to 45 minutes, and after that we will start the discussion about the subject. Thank you, Professor. Now the word is with you.
Thank you very much. It's an honor to speak to you. I'll be speaking about a classical tradition that stretches back to Aristotle, in which private rights were defined in terms of the purposes that they serve. To understand the scope of the right to own property or to enter into contracts, one must understand the purposes served by property and contract. Since the 19th century, private rights have been defined as zones of freedom within which the right holder can do whatever he chooses. Any limits to how a person may use his property or the terms on which he can contract necessarily curtail his rights. They may be justified by some larger social goal, but they curtail his rights all the same. By the older approach, they need not do so. They may delineate the scope of his rights rather than restricting them. Rights do not extend beyond the purposes for which they are established. So the reason that there are limits to the freedom of a right holder is that he can't exercise a right that he never had by the older approach. In the classical tradition, the promotion of the common good was believed to be in harmony with the exercise of private rights. Excuse me just a second. Since the 19th century, the common good has been envisioned either as an aggregate of private rights or as a social goal that's independent of them. In the first case, the promotion of the common good is merely a matter of promoting private rights and interests. In the latter, it's a goal to be pursued at the expense of private interests. The classical tradition has all but forgotten the conceptions of private rights and the common good that are familiar to us now create problems that we are unable to resolve. We'll see how the classical tradition resolved them. In the 16th century, philosophers and jurists began to use the term right, the term jus in Latin, in a general sense to refer, for example, to a right of property rather than a particular right, such as a right of way. The change was really one in vocabulary. Some scholars have thought that the change was a difference in it represented our recognition of rights in the sense I've just described, in the sense now familiar to us. But the real change began in the Middle Ages when Thomas Aquinas drew on Aristotelian philosophy to explain what were later called private rights, such as the right of property or the right to confer on contract. This major change that began with Aquinas culminated in the 16th and 17th centuries in the work of a group centered in Spain and known to historians as the late scholastics. The group was founded by Francisco de Vitoria and Domenico di Soto. Among its leaders were Louis de Molina, Leonard Lessius. They synthesized Roman and canon law as interpreted by the medieval jurists with Aristotelian philosophy as interpreted by Thomas Aquinas. According to their approach, property was not an unqualified right. It was established to avoid the disadvantages of common ownership. The owner's rights are therefore limited by the purposes it served. Contract was an act of commutative justice. It was not merely the expression of the will of the parties. Consequently, the rights and duties created by a contract were limited by the purposes they served. This approach was followed by Hugo Grotius, the founder of the Northern Natural Law School, although without the same commitment to Aristotelian philosophy. It was replaced by the familiar one just described, in which a private right is defined as in unqualified terms as a zone of freedom in which the right holder can do as he chooses. Property, in principle, or by definition, is the right of an owner to do as he wills with what belongs to him. Contract and the duties defined, and contractual duties, are defined in terms of the will of the parties to bind themselves to whatever terms they choose. We associate this modern conception of rights with 19th century liberals, such as Immanuel Kant, and yet it was held by 18th century rationalists, such as Gottfried Wilhelm Leibniz and Christian Wolff. It was also held by 19th century jurists who seemed to have arrived at it independently of the influence of philosophers, liberal or otherwise. The common feature was not a philosophical commitment. It was an attempt to define rights without any regard to any purposes except those of the right holder. I'd like to begin then by talking about private rights in the Aristotelian tradition, and then we'll get to modern ideas of private rights. In the Aristotelian tradition, rights such as property and contract were understood in terms of distributive justice and commutative justice. Distributive and commutative justice were understood in terms of their contribution to human well-being. Human well-being, eudaimonia, happiness, consists in living a distinctively human life, a life which realizes so far as possible one's potential as a human being. It is a life unlike that of other animals, because a human being can act not only by appetite, but by reason and will. He can understand that an action contributes to the distinctively human life that he should live, and he can choose it for that reason. Living such a life is the ultimate end, which all well-chosen actions are a means, either instrumentally or as a component part of such a life. Because a human being is a social animal, part of living such a life is helping others to live it as well. To live it, a person needs not only virtues, but some external things. A person should try to acquire what he needs and help others to do so. Distributive justice gives each person a fair share of the resources that he needs to accomplish to live such a life. And commutative justice allows him to exchange with others without diminishing their fair share, their share of the wealth. The right to property was understood in terms of distributive justice. Distributive justice ensures, as far as feasible, that each person has, in Aristotle's words, a fair share of, quote, honor or money or other things that fall to be divided among those who have a share in the Constitution. It follows a geometric proportion. Those who merit more receive proportionately more. In the Politics, Aristotle illustrated the principle of distribution according to merit by discussing how he would divide up flutes among flute players. He said that when a number of flute players are equal in their art, there's no reason why those who are better born should have better flutes. They won't play any better on the flute. And he said the superior instrument should go to the superior artist. Elsewhere, he suggested why distributive justice is not simply a matter of determining who is best able to use resources and dividing them accordingly. Societies with different political structures will differ as to what constitutes merit. Democrats, he said, will identify the status of a free man. Supporters of aristocracy will identify it with excellence. Moreover, it would be wrong if all the resources in society were held in common and then assigned to whoever could make the best use of them. Instead, a society needs to institute private property. Plato had thought that in an ideal society, all things would be held in common. Aristotle objected that if it were so, quote, those who labor much and get little will necessarily complain of those who labor little and get much. Aquinas gave a similar explanation. The late scholastics and Hugo Grotius concluded that all things are in common ideally, in principle, in the beginning. Private property is instituted to remedy the defects of common ownership, the ones that Aristotle and Aquinas described. It followed that the rights of property owners are limited by the purposes for which private property is instituted. A good example is a doctrine formulated by the canon lawyers. A person in times of necessity has a right to use another person's property against that person's will. According to Aquinas, quote, despite the division of things, man's needs have to be remedied by these very things. Therefore, when the need was manifest and urgent, quote, it is lawful for a man to meet his own need by means of another property. And Lessius, Soto, Molina agreed, as did Grotius. Once you understand the purpose of property, you understand why the owner's rights are limited in time of necessity. Contract was understood in terms of commutative justice. Commutative justice preserves the share of resources that belong to each person. In involuntary transactions, what we would call tort or delict, one person takes or destroys what belongs to another. Commutative justice requires that he make compensation. In voluntary transactions, each party gives something in exchange for what he receives. Commutative justice requires that what he gives is equal in value to what he receives, so that neither party is enriched at the other's expense. Following Aquinas, the late scholastics used this principle to explain what the medieval lawyers called lesio enormis. It's a remedy for a severe discrepancy between the contract price and the fair price. According to Aquinas, in principle, as Aristotle said, commutative justice requires equality. For pragmatic reasons, the law gives a remedy only for a severe discrepancy. And again, the late scholastics agreed. According to the late scholastics, the price that preserves equality is the market price on the day of time of the transaction. That idea has puzzled modern scholars. The market price fluctuates. It's determined by supply and demand, and those forces seem to have nothing to do with fairness. The late scholastics understood that the market price does fluctuate from day to day and from region to region. They believed, like modern economists, it must do so to reflect factors that they called need, scarcity, and cost. Consequently, exchange at the market price preserves equality only to the extent feasible. Further inequalities may arise when market prices changes. The market price changes. But the fact that one must tolerate those changes if the market price is to adjust to need, scarcity, and cost is no reason to tolerate the further inequalities that arise when, as Lessius put it, one party took advantage of the other's ignorance or necessity to charge more or pay less than the market price. Moreover, as Soto and Lessius observed, a party who gains if prices later rise might well have lost if they fell. Both parties ran the risk that future price changes would make the bargain unfavorable, but at the time they contracted, the contract did not favor either party. By the earlier approach, then, a person's rights depend on the reason that the right is recognized by society. Private property is established to avoid the disadvantages of common ownership. The owner's rights are limited according to that purpose. Contract enables the parties to exchange without one enriching himself at the expense of the other. The purpose of contract is not served by an exchange on unfair terms. A party who refuses to allow his property to be used by a person in urgent need, or who charges an unfair price, does not misuse his rights by exercising them in a way that harms others. He had no right to act as he did. Conceived in this way, the rights of owners of property or of contracting parties belong to them as members of society. One cannot explain property or contract apart from distributive and commutative justice. One can only explain distributive and commutative justice by their contribution to a just social order. Now, today, we're more familiar with a modern conception in which a right is a zone of freedom within which the right holder can do as he wills. An owner can do as he wills with what belongs to him. The contracting parties can contract on whatever terms they will. The modern innovation was not to introduce the concept of will. It was to leave out the considerations of justice, anchored in the social order that once defined the content of rights. We identified the new conception of property with 19th century liberal philosophers such as Immanuel Kant. Yet, it had been introduced by the rationalist philosophers of the previous century, and it was accepted by many 19th century jurists who were not influenced by liberal philosophy or philosophy of any kind. The rationalists, such as Gottfried Wilhelm Leibniz and Christian Wolff, thought that to reach conclusions with certainty, you have to use the method of mathematicians. You should begin with definitions and trace their logical implications. By beginning with the definitions of high-level moral concepts, the rationalists hoped to derive conclusions about moral law. Their definitions of legal concepts had no more relationship to the purposes of contract and property than a mathematician's definition of a triangle has reference to the purposes of triangles. They define property as the will of the owner to do as he wishes with what he owns. Wolff said the owner, quote, has the right to dispose of the thing subjected to him according to his own judgment, arbitrio. The right, quote, of disposing of a thing by one's own decision, indeed, is what we call ownership. Contract or promise was defined in terms of the will of the parties. According to Leibniz, a promise is, quote, a declaration that something to your benefit is to be done by me. According to Wolff, it is a declaration of our will to perform for another, joined with the right of the other person to demand transfer of what has been performed. Kant based his moral duty on what he called the categorical imperative, which can be formulated so act that the maximum of your will could always be viewed as a principle of universal law. His critics have claimed that the attempt to derive conclusions from the categorical imperative is fruitless. Some have noted that when Kant tried to do so, he invariably relied on an independent premise, a premise that did not follow from the categorical imperative, but without which he could not have reached his conclusion. Examples are his conclusions that one must not take another's property, that one must keep one's promises. To do otherwise, Kant said, violates what he called strict duties. Strict duties arise, quote, when actions are so constituted that their maxim cannot without contradiction even be thought as a universal law of nature, let alone could one will that it should be one. Kant's claim that one could not even think that it might sometimes be right to appropriate another's property or to break up rather a promise rested on his definitions of property and promise. They were like those of Leibniz and Wolff. Property is the right of the owner to use a thing as he chooses and to exclude others from doing so. Quote, anything is rightfully mine when I am so connected with it that if any other person should make use of it without my consent, he would do me an injury. A promise, Kant said, is the expression of the will of one party to contract, and a contract is the expression of the will of both. Making a deceitful promise cannot be willed as a universal law because, quote, it would contradict itself. Quote, the promise itself would become impossible. If someone were to ask, why should I keep a promise? The answer, according to Kant, is, quote, it is utterly impossible to give a proof of this categorical imperative, just as it is impossible for a geometrician to prove by logical inference that to make a triangle, I must use 3 lines. For Kant, then, a promise is binding by definition, as it was for the rationalists. By defining property and contract in these unqualified terms, Kant was able to conclude that the rules that govern contract and property were matters of universal law, which, quote, must hold always and necessarily, which is what the categorical imperative requires. The conclusion followed, however, only because of the way he had defined property and contract. By the 19th century, the work of the northern natural lawyers such as Hugo Grotius and that of the rationalists had been discredited. It was an age of legal positivism. Jurists claimed that their conclusions were derived from texts that were legally enforced in their own jurisdictions. Although the 19th century positivists rejected rationalism, their method resembled it more closely than they acknowledged. The rationalists claimed to derive conclusions logically from definitions, the way mathematicians do. Their conclusions were supposed to have the same certainty as the definitions. The positivists claimed to derive conclusions logically from authoritative texts. Their conclusions were supposed to have the same authority as the texts. If the interpreter were to add anything that did not logically follow from the texts, his conclusions would lack their authority. He would be usurping authority by making law. Another resemblance was the way the 19th century jurists defined basic legal concepts. We speak of the 19th century as an age of conceptualism and also as an age of will theory. Supposedly, the German jurists derived their conclusions from the texts of Roman law, the French from the texts of the Civil Code, and the Anglo-Americans from decided cases. Yet, they all defined property and contract the same way, and indeed the same way the rationalists and Kant defined it, in terms of the will of the owner of the contracting parties. They defined property as the power of the owner to dispose of what belongs to him according to his will, without any qualification concerning the scope of his right. This definition did not explain the law even in their own day. Sometimes the owner does not have the right to do as he wills with his property. The most obvious case is the one we've considered, when the property is urgently needed by another person to save his own life or his own property. According to the doctrine of necessity, the owner cannot stop him from doing so. Even before the will theories came under attack, American courts recognized the right of a ship in distress to tie up to a pier in a storm without the owner's permission. Although the German will theorists disparaged the doctrine, it was adopted by the German Civil Code of 1900. According to the Drafting Commission, the justification of the doctrine of necessity is, quote, every private right carries the inherent limitation that it must give way to the general interest, and when such a higher interest is present, is decided by the judgment of the community. Now, paradoxically, this description of the inherent limitation of property rights assumes that property rights are conceptually limited, unlimited, as the will theorists said. The Drafting Commission cannot admit that an owner must always exercise his right to promote the general interest. If that were so, private property would cease to exist. Rather, the owner's right to do as he chooses with his property must sometimes give way to the general interest. The private right is in conflict with the general interest, and when that's true, the general interest limits the private right. The 19th century jurists defined contract in terms of the will of the parties to do whatever they might will. Their definitions were not based on account of why society should enforce contracts or why the will of the contracting parties should be respected. As Valéry observed of the French will theorists, they took the binding force of contract for granted. They didn't demonstrate it. And she quotes Gounod's characterization of their view. The contract is obligatory simply because it's the contract. Like their definition of property, this definition cannot explain the law, even as it was in the 19th century. Sometimes contract does not enforce the terms agreed upon by the parties because they are too harsh. Even in 19th century America, courts of equity gave relief against, quote, unconscionable bargains. In France and Germany in the 19th century, relief was still given for lesior enormis. The jurists were puzzled. They said that either such relief was a mistake or it was an exception to the basic principles of contract law. Another problem for the 19th century jurists was that the law reads terms into a contract that the parties never envisioned, let alone willed. If the will of the parties is the source of their obligations, it's hard to explain why they should be bound by the terms the law reads in. Some jurists said that these terms were in some sense willed by the parties, but they never explained how that could be. Other jurists rejected the will theory because it couldn't explain where these terms came from, such as Oliver Wendell Holmes and Samuel Williston in the United States. One might think the 19th century jurists were borrowing from the philosophical, political, and economic theories which were fashionable then, in which the will of the parties played a major role. On even a cursory review, however, the will theory seemed different. The will theorists did not discuss whether Kant was right or why the will mattered. The feature which the will theories of the 19th century and liberals such as Kant have in common is that they explain private rights in terms of the will of the right holder without reference to those earlier concepts which had once explained the role that the will ought to play. And you can say the same of the rationalists. That's why these theories are similar. The will is the only concept that their proponents still trusted. The Aristotelian ideas about distributive and commutative justice and the relationship to the purposes of contract and property were ignored or forgotten. Private right was now defined in terms of the will alone, without any of the concepts that once limited it. Let's talk about the common good. When private rights are conceived in terms of the will alone, without the concepts that once limited them, the role of government is conceived to be either to protect those rights or to curtail their exercise in order to secure some social benefit. The public or common good is conceived to be to promote either the interests of individuals or a goal that transcends their interests and is to be promoted at their expense. Gordon Wood, I think a great example of this is the controversy among American historians, which was started by Gordon Wood. He showed that few ideas were more important to the founders of the American Republic than that of the public or common good. He said, quote, "No phrase except liberty was invoked more often by the revolutionaries. Quote, to make the people's welfare, the public good, the exclusive end of government, became for Americans their pole star and a central tenet of Whig faith." Wood observed correctly that this commitment to the common good, quote, embodied the idea of a good society that had been set forth from antiquity through the 18th century. He noted correctly the common interest was not, as we might think of it, simply the sum or consensus of particular interests that make up the community. The trouble is that the meaning of common good in this ancient tradition had been forgotten. Wood concluded, incorrectly, that since the common interest was not the sum of particular interests, it must be, quote, for the Republican patriots of 1776, the commonweal was all-encompassing, a transcendent object with a unique moral worth that made private considerations fade into insignificance, unquote. Quote, ideally, republicanism obliterates the individual, unquote. Now you can see why if you write a book like that, it might cause some controversy in the United States. But as we will see, that is not how the common interest was understood before the 19th century. The common good was the object of a virtue that Aristotle called general justice. The pursuit of the common good is no more in conflict with the protection of the rights of citizens than general justice is in conflict with distributive and commutative justice. General justice was defined in terms of the object or goal of human society. A human being lives in society with others because, as Aquinas said, paraphrasing Aristotle, he is by nature a social and political animal. He must do so to flourish as a human being. It followed for the late scholastics and for Grotius that by their very nature, human beings can form a society and institute a government. The end of government is to promote the common good, which is the flourishing, the happiness, the well-being, the eudaimonia of each of its members. Aristotle said, quote, "The form of government is best in which every man, whoever he is, can act best and live happily. To promote the common good is to promote the flourishing of each individual. To flourish, each individual must live a life in which he helps others to flourish as well, which is a life in which he promotes the common good." Aristotle distinguished general justice, which is concerned with the common good, from particular justice, which concerns the relationship of citizens to the state and to each other. Distributive and commutative justice are types of particular justice. In speaking of general justice, Aristotle said, "We call acts just that tend to produce and preserve the happiness of its components for the political society. All virtuous acts promote the happiness of oneself and others." Aristotle concluded that general justice is not part of virtue. It is, quote, "virtue entire." Quote, "This form of justice is complete virtue, not absolutely, but in relation to our neighbor." Aquinas explained, quote, "The good of any virtue, whether that virtue directs man to him in relation to himself or in relation to other individuals, can be referred to the common good to which general justice directs, so that all acts of virtue can pertain to general justice insofar as it directs man to the common good." Molina explained that general justice is, quote, "the act of any virtue whatsoever, not considered in itself, but insofar as it is ordered to the common good of the multitude, of which one who exercises the virtue is a part." To illustrate that idea, suppose a carpenter works to support his family. In doing so, he exercises the virtues of domestic prudence and care for the members of his family. His employer might pay him a just price, and he might do a good job in return. Each party is exercising the virtue of commutative justice. He might find his work worthwhile because he knows the house he is helping to build will provide shelter and beauty, which others will enjoy. But he may be doing all of these things because he wishes to live in and to contribute to a society which is good for himself and for all of its members. If so, all the other ends and all the other virtues, the exercises in pursuing these ends, belong to this ultimate end. In pursuing them, he pursues the common good. This ultimate end is not only in harmony with his private ends. Without them, his pursuit of his private ends might be worthwhile, but it would be incomplete. Let's return to the founders of the American Republic. Wood is correct about the significance to them of the public interest. The two who thought for us, we say, in the time of the Revolution were John Adams and Thomas Jefferson, who became bitter enemies. John Adams wrote, quote, "The public good is the professed end of all government." Thomas Jefferson said this is the one point on which he and Adams agreed. Quote, "Both are political parties, at least the honest portions of them. agree conscientiously in the same object, the public good, but they differ, essentially, in what they deem the best means of promoting that good. Nevertheless, Wood was wrong to think that because they did not conceive of the common good as an aggregate of private rights or interests, they must have thought it was, quote, a transcendent object with a unique moral worth that makes private considerations fade into insignificance, or that ideally it obliterates the individual. That an eminent historian should think so shows how thoroughly the older concept of the common good has been forgotten. To prove his point, Wood quoted passages such as the following. He quoted an anonymous Protestant minister who gave a sermon in which he said, quote, "In a republic, each individual gives up all private interest that is not consistent with the general good, the interest of the whole body." He quotes Samuel Adams, quote, "A citizen owes everything to the Commonwealth." He quotes Benjamin Rush, quote, "Every man in a republic is public property. His time, his talents, his youth, his manhood, his old age, nay, more, his life, all belong to his country." Those passages puzzled another historian, Lance Banning. He noted correctly that the revolutionary thinkers seldom hoped that individuals would not pursue their self-interests. A vigilant and vigorous defense of one's own liberty was thought to be a necessary characteristic of a citizen of the Republic. It was the contribution of his virtue to the public, unquote. Banning concluded that the passages I just quoted from Wood must be atypical. Not at all. Adams and Rush saw no conflict between their sentiments and contemporary ideas of what the public good entailed and what the private good entailed. Nor was there any conflict in the ancient tradition in which they were writing. Samuel Adams said, "A citizen owes everything to the Commonwealth." He does. Only as a member of society can he live a truly human life. Rush said, quote, "His time and talents, his youth, his manhood, his old age, nay more, his life, all belong to his country." Perfectly true. If he uses his time and talents well, in youth, manhood, old age, whatever he does will promote not only his well-being, but the welfare of his country. But his ends as an individual human being are thereby promoted, not disregarded. The anonymous Protestant minister, quoted by Wood, said that in a republic, quote, "Each individual gives up all private interest that is not consistent with the general good, the interest of the whole body." John Adams explained that if you assert a private interest that is inconsistent with the general good, you're overstepping your rights. To assert such an interest, a person asserts such an interest when he seeks unjust advantages, extravagant and unconstitutional emoluments, and he's motivated by, quote, excessive ambition and venality. In contrast, a person contributes to society when he asserts his rights from, quote, resentment of injury, indignation against wrong, love of virtue and truth, veneration for virtue, through understanding, seeing, and feeling the difference between true and false, right and wrong, virtue and vice, and so he defends the liberty that society should protect. There is a harmony between asserting one's true rights and promoting the common good. The conceptions of private right and the public good that are familiar to us misconceive both ideas. If private rights are regarded as a zone of freedom within which the right holder can do as he wills, we cannot understand such basic rights as to own property and to make contracts. If the right holder does not possess an unqualified freedom of action, it is misleading to imagine that he does so in principle, but that the law abridges his rights to prevent him from harming others. If private rights are conceived of in this way, then the public good becomes either an aggregate of the interests of right holders or an independent goal that can be promoted only by curtailing their rights. The founders of the American Republic believed that the protection of private rights and the pursuit of the public good were in harmony. Today we navigate between two unreasonable extremes. It was not always so. Before the 19th century, private rights were believed to be limited by the purpose which they legitimately serve. The exercise of private rights was deemed to promote the public good. We have lost sight of the concepts of distributive, commutative, and general justice that supported this belief. Thank you.
Thank you very much, Professor James Gordley. Excellent for us. It is a great honor to have you here, as I said before. And now I can open to the debate, the discussion. I think we can start with our professors that are here with us. I don't know if Professor José Reinaldo de Lima Lopes is here. Professor José Reinaldo is...
yes, I'm here.
Thank you, Professor José Reinaldo.
I can use my camera too, whenever you say.
You can open.
Yeah, I can open it. I hope. Yeah, there it is.
Thank you, Professor.
Is it working?
Yes, now it's working. Would you like to start our discussion?
Yeah, sure. So I'll start, of course, first of all, thanking Ricardo, who has organized the meeting, and Luis Barzotto, who invited me, and of course the presentation made by Professor Gordley. He probably doesn't remember. We met 20 years ago when he was still in Berkeley, and I was visiting and doing my research at the Robbins collection. So for starts, his influence in my work has been very deep, I would say. I have just received his paper 1 hour ago, so I won't be able to do much of a reaction in depth, but I would like to at least suggest 2 lines of discussion. I just would like to know if you hear me and if you see me right.
I do hear you.
Okay.
Can't. We both,
all right.
Our appearances both changed in the last 20 years, I suppose. But I'll bet if you mention the conversation, I'll be able to remember the conversation.
You were. Well, I was working on exactly the idea of justice in the early modern period and how it changed our conception of law, after all. And that's basically what I'm going to suggest. Of course, I'm in line with you with this idea. The broad idea, which I think I share with you, is that the very idea and concept of justice has been abandoned by jurists in general. As you said, we are in still in a positivistic age, so we think law can be understood by itself without any reference to a larger meaning. So first thing is, my reaction is that I think that we can't understand just law and legal institutions in general, both in private and public law, without the idea of justice. So I think that what you say, what you mention as the purpose of an institution is ultimately what I call, well, many other people call it, the sense of justice. That is, you need a sense of justice, what is at stake in relations among human beings, either as human beings or as citizens, that is as part of a public community, of a communitas perfecta, or as part of a contract and an institution. The sense is given by the idea of justice. So first thing is that we need that, and it's curious that in law schools, we don't have any course on justice. Well, we leave justice for political philosophy or political science, and justice, which should be the ultimate sense of law, is forgotten. So we teach our students that they can think of law, about law, without thinking of justice. So first thing is, one thing that you have been working on, and I think is very productive, is this, that you have to go back to the theory of justice. But then I think I have a different reading of justice, because I go with that's my reading of Aquinas and Aristotle. I think there is a difference in political or general justice, which deals with the common good of a republic, and a difference then with the particular justice, which may deal with the common good, but only the common good of definite groups. For instance, joint property of common heirs to a deceased person, or the case of bankruptcy. Although contracts were made between the bankrupt firm and its creditors, after the bankruptcy, they cannot pursue their interests individually. And this is very interesting, because in law, we say in our common law, civil law, and you know the tradition, that the patrimony, the assets of the bankrupt person or firm becomes a whole, a universitas, actually. So that's one important point, and I think that your work helps us understand that. So the common good is not only the political common good, it can be the common good of private persons. And that's my reading of Aquinas and Aristotle. And my reading would be that the difference between the political justice and particular justice, or legal justice and particular justice, is the kind of good that is at stake. In the first case, the political justice, the good cannot be individual good. Whereas in distributive justice, you have a common good, but the common good of a restricted group of persons. That's my idea, but it's still common. So my second point is that we have to study again, rewrite, and rethink about the idea of good in private law. Of course, I'm speaking from the Brazilian experience, and we tend to think of the good in private law as something that can be valued by money. If you look at the doctrine of private law in Brazil, and you look at the what they say, law professors in Brazil, scholars, legal scholars in Brazil, they say, well, a good is always something that you can buy in exchange for money. But I think that's not even true for private law, because you have goods like your name, your what we call the personality rights here in Brazil. That cannot be exchanged. So what we have to think about is, again, the idea of good, and see that, as you say, since the 19th century, we have a very restricted idea of what the good is. Because for general purposes, legal scholars think of good in this very restricted private law conception of good. So I think this is just a reaction. I think there are 2 points that we share, at least we share the preoccupation with these points. And I would add, just to finish, a third point, which I like about your work, and I think it's very valuable for us here in Brazil. I think what we need is to go back to jurists. Well, you have a book called The Jurists, and jurists have theories about society, and I think we have to go back to jurists in general. I think since the 18th, maybe probably the 19th century, we tend to do legal history and legal theory reading the philosophers. But the jurists also suggested things that we have to revisit and recover and think about them again. Like, even, for instance, if you go back to the German tradition, Savigny had theories about what law is, about what the doctrine is, and we forgot that. Jennings, of course, had theories about the society, law, and everything, and we don't read them. I think it's necessary to read them again, because what they are suggesting is what we receive is a given tradition, and we have to rethink our tradition. So I'm sorry for this fragmented reaction, but of course it's from someone who does study these things, and at the same time have just received your paper an hour ago. But thank you very much. I think there is a lot to talk about concerning these issues. Thank you very much, Mr. Gordley.
Well,
good to see you again.
Thank you, and I think we agree more than perhaps you realize. At any rate, your third point I endorse completely. It's very odd that jurists don't think about justice, and it's very odd that political philosophers, don't know any law.
Right.
Part of what made the period of the late scholastics so productive is that these people could do both and learn from the law. As to your second point, yes, you're absolutely right. There are all sorts of things that are goods that are protected by rights that are not reducible to money. Aristotle said that distributive justice distributes honor, wealth, whatever else can be unequally divided. The late scholastics said that as a matter of commutative justice, if I have hurt you, they use the examples you do. If I have hurt your honor, that's a violation of commutative justice. And then, of course, the question is now, how do I restore that to you? And ideally, the way I should restore it is by telling the truth, admitting that I told a lie. But, compensation was a secondary. It was not that your honor is worth money. It's just, what do you do? It's like when somebody's arm is cut off, you make compensation in money because it's the best you can do. They certainly would have agreed with you. Coming back to your first point, I agree with you. I agree that the object of general justice is the common good, meaning the good of the entire society. And distributive justice and commutative justice are not general justice. They are particular justice. They have their own distinct objects. Distributive justice, the relation between the state and the citizen, and distributing whatever is to be divided. Commutative justice, and preserving for each what is his own. The objects of those virtues directly are not the common good. That's the object of general justice. Now, the thing about it is you could promote general justice directly. For example, when the state takes an action to benefit everybody, it's pursuing the common good. Okay. But the mystery, the trick here, I think, is suppose I'm doing an action, and it could be an action which is good, any good action, any action of any virtue. For example, it could be I'm studying. It could be that I'm being kind to someone. It could be that I'm being brave in defense of my own house, not in defense of the Republic. It could be that I'm doing a good job at my work. It could be that I'm paying somebody an honest wage who works for me. Now, these are acts of various virtues, and some of those virtues are things like commutative justice, and others are virtues like courage, prudence, and so forth. The way I read Aristotle and Aquinas, and I think I have Molina on my side, is that when I perform one of those acts, even though it is the act of a particular virtue, and you can explain that particular virtue without using the term common good, nevertheless, that very act, because it contributes to my well-being and the well-being of another, promotes the common good of the Republic, because the common good is the state in which everyone flourishes, everyone lives a good life. So now, there's a Leonard Lessius took much the view that I think you were taking. He said, look, the general justice concerns the common good, Aristotle says. How then can it be the act of every virtue? I mean, if a citizen acts to promote the common good, surely it's some virtue like observantia, obedience or respect for authority, or something like pietas, which is respect for authority. And Molina said, no, if we read Aristotle correctly, we realize that an action can promote a particular virtue, and just because it promotes that particular virtue, it promotes a society which flourishes, and that is the object of the common good. Remember my example of the carpenter. He does a good job for a good wage. That's commutative justice. He does it because he wants to help other people in the society create something that's beautiful and will give them shelter. But he may want all of those things because what he wants is to be part of, to contribute to a society in which everyone flourishes. And to that extent, all these other virtues are performed for the sake of that kind of a society, for the sake of the common good. So I think I can agree with you as to the object of general justice is the common good, that distributive and particular justice have their particular objects, and still say, yeah, but the objects of particular and distributive justice and any other virtue are in this sense subordinate to the common good.
Yes, I agree with you with that too. Yeah, there is a story people tell about a carpenter or a stone carver who was working in a cathedral. Probably many of us know it. And then when asked, "What are you doing?" He says, "I'm doing my job." And the other carver in his side said, "Well, I'm carving this stone for the door." And the third one says, "Well, I'm building a cathedral." So different dimensions of the behavior. Thank you very much. Yeah.
Thank you, Professor José Reinaldo. It's an honor to receive you here in our group too. And now I think we have Maria Bofill is asking to talk.
Hi, thank you, Maria. Thank you, Rafael. First, Professor Gordley, I must say it's an immense honor to be with you after 14 years since I finished
Thank you for your excellent paper.
Yes, Professor Gordley advised my thesis paper during my LLM at UC Berkeley Bolt Hall. I read your article, and it's all in line. All your lessons on the notions of fairness. They always seem very present in your articles, and it's always immense lesson to learn. But when you mention here that private rights, they're defined in the terms of the purpose that they serve, and beyond such purpose, such right doesn't exist, right? So you're not limiting something that do not exist.
Right.
And exercising also, right, that exercising legitimate individual rights contributes to the common good, as the perfection of a part perfects the whole, right?
Right.
And whatever contributes to the well-being of a member contributes to the common good, as the end of the society is the well-being of its members. This all makes perfect sense, and it also corresponds to the ideas of our common sense, right? However, and especially in these times of polarized ideas, which the COVID crisis seems to make even more acute, the challenge seems to be how to do this 19th century conception that still prevails of individual rights, of zones of freedom, how to actually convince people that you're not limiting a right, as such rights have never existed.
I can't imagine. I mean, this idea, this modern idea of what a right means is so entrenched that, as I say, even the fact that there is an earlier idea has been largely forgotten. Even an eminent historian like Gordon Wood, because he's only an historian of the revolutionary period in America, doesn't know that there ever was a different idea. All I can say, and I can't I don't believe that because an idea is right, it's going to destined it to triumph. If that were true, we wouldn't have the problem in the first place, and I wouldn't be giving a speech about how these ideas have been forgotten. All I can say is there was a time when the people who were advancing the ideas that I criticized, those were new. Those were new. And they did it partly because they debunked or forgot about ideas like human nature, and consequently ideas of commutative, distributive, general justice that went down with human nature. You had the rise of a kind of a, if not a philosophy, at least a belief that human nature varies indefinitely, and therefore there's no standard for conduct, and therefore protecting a right means protecting freedom, freedom to do anything. Now that idea had an origin, it had a start, it prevailed. I don't think it was destined to prevail either. So I don't know how to make it go away. But then again, it seems to me a real historical accident is there in the first place. Something made it spread. I know I'm sounding very odd. It's like the guy, the American serviceman who was on duty, when a superior officer came up to him and said, "All right, soldier, what would you do if you saw a battleship coming at the fort across the drill field?" And he said, "I think I'd sink it with a torpedo, sir." And the officer said, "Now, where are you going to get a torpedo?" He said, "I'll get it the same place you got the battleship." So yeah, I mean, we'll get rid of this the same way it came, but I don't know what that is.
But thank you so much for your thoughts.
Sure.
Thank you, Maria. Thank you, Professor Gordley. And now I don't know if the others would like to ask something. No? So I think I have some questions, some points to ask about for Professor Gordley. Professor Gordley, first I would like to hear you about the role of the Constitution in this this order of general justice. There is a role for Constitution. This is my first point. The second point, or the second question, is if the general justice, or the legal justice, or the social justice, if we can connect them, could be a criteria to balance commutative justice and distributive justice, because we have sometimes this tension between distributive justice and commutative justice. And the third point is about human rights and human dignity in the substance of general justice. If you see these modern concepts as a substance now for this social or general justice.
Can you remind me of your first point?
My first point is about the role of the Constitution in a country to establish the order of the general justice.
Okay, of course, my experience is mostly with the American Constitution. I've just written another unpublished piece that I think is an answer to your question. Historians looking at the American Constitution, at least before Wood wrote, described it as instituted in order to protect private rights, the way 19th century people understand private rights. if I'm right and Wood's right, that is not the way people understood private rights or the public interest at the time of the Revolution. What changed and when did it change? Well, my answer is I think the Constitution was inspired by the idea of the common good as I have just described it. I think you can see that with James Madison in his Federal commentaries on the Constitution, known as the Federalist Papers. You can see it in the debates. Their question was, what form of government will best promote the common good? And that's not only a very Aristotelian question, but I show in my article that they considered the three forms of government that Aristotle described that could promote the common good: monarchy, the rule of one; aristocracy, the rule of the best; democracy, the rule of the many. And if you read Madison, you can see that he is trying to describe how the American Constitution creates a mixed form of government that balances those three elements so as to promote the common good. And what he doesn't want private interest to subvert the common good. So my answer is, I don't think you can really understand the Constitution without understanding this earlier idea. And it was only in the 19th century, I think, that American liberals in the 19th century sense read their ideas backward into the Constitution, which had various serious consequences in the United States that we haven't yet recovered from. It's that period when the pursuit of happiness and the Declaration of Independence came to mean not the pursuit of happiness in the Aristotelian sense of eudaimonia, but doing what you want, getting what you want. And the Constitution is supposed to help you to do that. Your second point about the trade-off between distributive and commutative justice and the general good, I think the kind of problems you're worried about are problems in which there's either an imbalance in how much wealth people have, which is the concern of distributive justice, or it's the fact that once I give somebody a share of wealth, he may use that in ways that don't promote good, whereas other people need wealth for good purposes. He's using it to buy the $10 million home in not terribly good taste, probably in California. It seems to me that difficulty arises just because of the answer they gave as to why we have private property at all. In an ideal system, you divide things up the way Aristotle says you divide flutes up among flute players. See who needs it best. You do it according to the need of different people. That would be perfect distributive justice. The thing is, you can't do that because it's dangerous. And also, look at the disadvantages. Because you're going to have endless quarrels, as Aristotle pointed out, as to who needs something the most. And people are not going to have an incentive to produce things and conserve them unless you have a system in which you have to live on your own budget. So you institute private property in order to avoid those disadvantages. And once you do it, you're going to have a very imperfect system of distributive justice. To begin with, things, instead of going to whoever needs the most, the best you can do for distributive justice is to make sure people have a fair share of purchasing power. Now, I may need a Steinway because I'm a great pianist, and you may need a flute, which is much cheaper, but we can only look to see whether our purchasing power is a fair share in a democracy, an equal share, whatever. And second of all, I don't lose anything if I spend my money badly, because we've decided that the society is not going to reach down and look at how people are spending their money and see if they're spending it according to what they really need. That's what we decided when we divided up private property. So I agree there's a tension, as you said, but I think it's built into the very fact that we do distributive justice not by evaluating each person's merits and needs, but by establishing a system of private property, then trying as far as we can to make sure that each person has a fair share without destroying the incentives to work, and then leaving people free to spend their money as they choose. That's my answer to your second question. And the third question again?
The third question is about the human rights and human dignity as a substance of general and social justice.
I'm sorry?
Pessoal, pode fechar os microfones, por favor? Okay, Professor, I think they closed the microphone.
Well, human dignity is one of the things that should belong to each citizen because he's a citizen. He's a member of the Constitution, has a part in the Constitution. It should also belong to him in the same sense as your personality rights, honor, and so forth, belong to him because, you know, he should be respected. That's human dignity. I don't think it should be confused with the idea that human dignity means whatever you do, I should respect it. And that tends to be the modern notion of human dignity or human freedom. And I don't think it makes sense that way, because the only reason for my respecting what you do is because I can see something there to be respected. Now, because you're a human being, there are lots of things we share. There are aspirations and goals. I can respect you because you're a human being and you're capable of seeing that those things are worthwhile and doing them. And if you actually do them, I can respect you for your virtues, as Aristotle would have said. But that means the very standard of respect is grounded in human nature. And it's grounded in the principle that there are better and worse ways to act, ways that are more dignified or less dignified, more consistent or less consistent with human dignity, worthy of greater respect or worthy of condemnation. If you cut the idea of human dignity or freedom loose from that foundation, I don't see what there's left of it.
Great. Thank you. Thank you very much, Professor. My colleagues here, our students, do you have more questions, please?
Rafael.
Who is speaking?
Professor Guilherme.
Thank you, Guilherme.
Dá tempo ainda para mais uma pergunta?
Yes.
Então vamos
Please.
lá. Vou abrir minha câmera aqui. Hi, Mr. Gordley. Would to thank your exposition. I'm very grateful to the rescue of the Aristotelian tradition. And my direct point is there is a way to harmonize the rights, the rights with the common good in the contractualism and the tradition of the social contract, because in the tradition of Aristotle, there's no property in the sense, the right sense, before the dicaion politicum, before the society. There's only possession. In Hegel, it's the same. The abstract right is just the first category of thinking of the movement of justice. There's no justice or law before the institutions, the Sittlichkeit. I think the social contract is does not harmonize. There's no a concept or a category that allows to harmonize common good with private rights. What do you think about? Thanks.
I think you're right that in the Aristotelian tradition, a human being lives in society because only in a society can he flourish. You can't talk about people capable of living a self-sufficient life, having rights, and then giving them up to form a society. In that sense, you can't speak about a social contract. That's your point, I think. However, you can speak about a social contract in another sense. Quentin Skinner, who wrote a classic on the history of political thought, says that the idea of the social contract did not begin in the 18th century with people like John Locke. It in fact began with the late scholastics. And I think he's right. And then I've written another unpublished piece trying to show that he's right. The late scholastics said that because man is naturally a social being, he lives in society. Now, do you want to call that a social contract? Well, certainly not in Locke's sense. You are a member of society. Because you're a human being, you're born into society. You can't live outside society, as Aristotle said, without being a god or a beast. On the other hand, your union with others in society is voluntary in the sense that it is an act of your reason and your will. You can see the society is good for you. You can understand that. And so you want it for yourself and for others. That's reason and will. Even though there's only one possible choice, so to speak, it's a choice that you would make. Second, there is no one just form of government, according to Aristotle. You can have monarchy, you can have aristocracy, you can have democracy. Each one promotes the common, could promote the common good. What the late scholastics said is this: therefore, there must be a moment when a society makes a choice as to which form of government to have. Now, this doesn't just mean there's one form of government and they all endorse it because it appeals to their reason and will. It means, no, there are different forms of government, and they have to choose one. And if you want to call a social contract the institution of a particular form of government by a people, yes, they believed in that. Yes, they believed in that. And how could it happen? Well, it could happen actually by voting. And they discussed the fact that if a majority wanted this form, then everybody should have to go along with it. It could happen by tradition or custom. It could be any one of the three Aristotelian forms. It could be a mixed form. And then they drew the conclusion that since this form of government is instituted to promote the common good, if it ever becomes unfaithful to the common good, it is the right of the people, it is their duty to alter and abolish it and institute such new form of government as may be more consistent with their safety and happiness. That language I just quoted, of course, is from Thomas Jefferson, the Declaration of Independence. Now, in the other thing that I wrote, I traced that idea, following Quentin Skinner's lead, through the early leaders of the Calvinist church, like Beza in Geneva, who were using it because they wanted a reason to defy their government. And through the British Whigs who were writing in the 18th century, Bishop Filmer, who defended the divine right of kings and may have invented the idea, said there's this terrible idea going around that the people institute the form of government that's best for them in their judgment, and then they can abolish it if it becomes bad. This idea is held by who? By the scholastics and by the leaders of the Reformed Church. He names the late scholastics as the people who launched the idea, and he's against it. And everybody who was a Whig in the 19th century, including in the 18th century, including Locke, ended up defending this idea, attacking Bishop Filmer, and that's where the founders of the American Republic get their idea. As it happens, only one of those people envisioned the social contract as what happens when people live in a state of nature independently and then give up their rights. That guy was John Locke. Every other one of the Whig writers wrote about the social contract in the same way that I've just described. It goes back to the Aristotelian tradition. 19th century liberals looking for ancestors found Locke, and they said, aha, that's the social contract. I don't think Locke believed in the conception of private rights that I've just described, really. I don't think he had a conception of human rights. I don't think he had a coherent conception of human nature. But at any rate, liberals in the 19th century got that and said, there, that's the social contract. And that's the idea of social contract that you've just criticized, that is incompatible with the Aristotelian tradition. But this other idea I've explained is not only incompatible, but is the historical source of the idea of social contract that played a role in the American Revolution.
Thank you, Professor. I think Carolina Correa would like to ask something. Carolina?
Yes.
Please.
If you have time. Thank you, Professor Gordley. I'd like to ask, in line with the question of Professor Rafael, the role of the Declaration of Human Rights in the realization of common good, just general justice also, because as Finney says, we can read the declaration also as in a dogmatic way. For example, in the Article 29, we see that some rights can be seen as absolute. Nobody can be submitted or in some ways, the human being cannot be submitted in certain situations. And others, everybody has the right to, can be seen in a relative way. In this line, the rights have been claimed as one thing somebody have in particular way, the individual bearer of rights. And also we see that, as Marianne Glendon says, that this rhetoric of human rights doesn't help in the realization of the common good of a society. And what can we say to the people, the normal people, the people we see in this time of polarization, that they can do what they want, also go to the church, also if they put in risk the life of other people?
Many of the people who talk about human rights are people I'd like to talk to about what they mean by rights. To the extent their idea of rights is a sphere in which the right holder can do whatever he wants, which is the idea I've criticized. To the extent that their idea of rights is cut off from any reason why people ought to have rights, to the extent that their idea of rights is cut off from any idea of human nature, then I wonder what's human about human rights. If it doesn't pertain to you as a human being, and if they can say nothing about human nature, why can they explain to me as a human being why I have these rights? And second of all, I think they're badly misconceiving rights if they imagine that it's a sphere in which anybody can do anything it wants. In fact, if they thought of the implications of that, I think they'd be the first to run away from them. Is it really true that I can use my rights to discriminate against other people on the basis of race or religion or whatever? Of course I can. And why is that? Because they have the right not to be discriminated against? Why do they have that right? Because they're human beings. What does it mean to be a human being? I think very often this talk about rights is running into a gap where we don't want to say the law is simply the will of the state. My goodness, hasn't the last World War, hasn't tyranny in the world taught us that the law can't be just what the state says? Therefore, they want to fight tyranny, and they want to fight it with a concept of rights. Good, but that can't be an empty concept of rights. Otherwise, you come very close to saying the reason you have these human rights is because we, the United Nations, say you do. And that's just as bad as saying our will is law. It has to be founded on some notion of what rights as a matter of justice people, because they're human beings, ought to have. And there you have a complete theoretical vacuum.
Thank you very much, Professor.
Thank you, Caroline. Thank you, Professor James. I think we are reaching our time. I don't know if there is one more question. No. So, Professor James Gordley, thank you very much again.
Thank all of you.
It's a great moment now to receive you here in Brazil, in our university. I would like to thank to professors and scholars that are here today with us, Professor Guilherme Boff, Professor Lúcio, Professor Fábio Andrade, Professor José Reinaldo, Professor Luiz Renato Ferreira da Silva, and Professor Luiz Fernando Barzotto, and the others that I can't see now in my line, but we had today more than 70 people with us for a group of philosophy of private law. You know that this is too much, and this is for us a very important thing to open the discussion about law and about the connection of law and justice. So, Professor, thank you. I don't know if you would like to say something in the end, please.
I'd just like to thank you all and for your questions, and I learn every time I speak, which is a very good experience. Thank you.
Thank you, Professor. I would like to maintain this partnership and continue to learning with you. Thank you.
Thank you.
And goodbye.
Bye-bye.
Bye-bye, everyone.